Hey, Bill, I'm Anita Quillman, your
Pleasure to meet you.
ethics advocate. I know we chatted briefly on the phone, and I think it's important we've got this face to face so I can make sure that you have any questions answered about the hearing, the process, what you should or shouldn't do, questions you may have for me, because I want you to be as comfortable as possible and prepared as possible to represent yourself in the hearing. Sound good?
Sounds very good. Yeah, I appreciate your
So
time.
good. So you've gone over the paperwork, and I know if you've signed the authorizations and the paperwork. So with the outline of the hearing on how it takes place, do you have any questions for me at the moment before we talk about any specific preparation?
I, how serious is this? Is this a big deal? I mean, is this a huge deal at this point?
Well, it can be a huge deal. I mean, with the code of ethics, violation of code of ethics can be a very big deal, from discipline to monetary um, citation or fees paid, and as well as the MLS rules. We're all independent contractors, but it's really important we all work within that umbrella of rules, code of ethics and MLS rules. So it can be a big deal, but probably most important on us working together is for you to be more clear about the hearing process, to be more comfortable and how it's going to work out, and more along the lines of kind of what to say, what not to say. And I don't mean that you're always going to be truthful, but
Of
there's
course.
other aspects about it. So, so the process, going through the hearing, there's opening. Each party has the opportunity to opening statement, then to better explain why we're here and your response of why you shouldn't be here, by the way. Questions and answers throughout the process, including from the hearing panel and both sides, closing statements, and then the close of the hearing. So that's the big overview. In the meantime, I think most important for you, we've already got your response prepared that's been submitted.
Hmm.
And so I think when we uh, kind of worked on that or retooled that, I think that's appropriate. But during the hearing, I guess I want to share with you some of the best things you can do during the hearing is you certainly want to appear to be the competent, nice, trusted realtor who likes and loves his clients and takes care of business. And I'm not saying that's not who you are, but sometimes it's harder in these hearings to maintain your composure for things that maybe you're accused of or the way it's being said. I think most important for you is to maintain your composure. So, for instance, I don't really know the complainant or their mannerisms or how they may come across, but in a hearing like this, it's probably important that you look like the calm, cool, collected, trusted realtor. Does that make sense? Any
Yes, it
questions
does.
about that?
No, not at all. No.
Okay.
So are you speaking or am I speaking?
No, you're going to be speaking. I mean,
Okay.
if there's something, remember my role in the hearing, I'm not restricted from speaking, but it's most important that you're speaking representing yourself.
Okay.
Uh, in other words, I'm not the one who needs to kind of show that I'm calm, cool, collected, trusted realtor. It's you.
Understood.
So in the hearing that can make a difference in anything during the hearing. If there's something that really was a misstep that's appropriate, sometimes it's appropriate to acknowledge that, and in a way that appears that you sincerely are remorseful for the misstep, if that's the case of one of these violations, code of ethics or rules. Does that make sense?
Yes, it does.
Because then it makes, human. If there's something that really was done wrong, like this is a confidential meeting, but however it happened, where you handed your key or access card to access the property, I don't know any way to get that around that being a violation.
Okay.
That makes
Understood.
sense.
Yes, it does.
I don't know any way to work around that or any way you and I can spin it. So what I'm saying is that there's something like that, I don't think there's real reason to defend too hard of the why. I mean, I'm not sure it helps you too much in your defense verbally to say that I had another deal blowing up, or however you phrased it in the information, that's okay situationally to explain it, but it's not really a good excuse to neglect your responsibilities because you got another deal going on. Does that make
Okay.
sense?
Yes.
So it's part of the facts, but I wouldn't lean into that. Does
Okay.
that make sense?
That does
And
make
so
sense.
for the most part, uh, some story is absolutely necessary, but you really don't want to be in the position of telling too much story so that the story, people have too many things to listen to the story as opposed to the facts. Remember, the hearing is specifically about the 2 code of ethics violations and the 2 MLS rules violations. That's what the hearing is about. So the presiding officer usually does a really great job of keep people narrowed in on track that were for the hearing. It's not anything outside of that, even though a little bit of the story. So you, with any questions you might have, you have the opportunity, by the way, to ask questions of the complainant. But in asking questions, really sound like the better person, the calm, cool, collected, and stay on track with any questions. And certainly on your presentation of staying on track of how you were doing your business, taking care of the clients, and why you're not in violation of either Article 1 or 3 or the other 2 items. Again, the tough thing about using your key to access the giving them. I'm not sure there's any defense for that, so I'm sure I can help you with that. But with the other items, calling the office, the information you got, that you were first trying to get in touch with the listing agent. I'm assuming that that's what it said in the MLS, probably appointment lockbox, if you recall what the showing arrangements were, and that you weren't able to get in touch with the listing agent. So the next best thing of what we all do is we call the office.
Okay.
Makes sense.
Yes, it
So
does.
so any other questions about that? Because otherwise, I think it's sticking to the story, maintaining your emotions, calm, cool, collected, and answering the questions, and not defending yourself, but not in an aggressive way. Really, kind of a matter of fact, calm, cool, collected way, so that you sincerely respectful and care about the process, but representing yourself in that way. Sound good?
Sounds good.
So any other questions for me
Not
about
this
the
time.
process or what to do? And so I'm going to be in the hearing with you just like we are now. But again, and if there's something, you always have the option to ask me something. And as a matter of fact, if you really needed to request a break, which I don't think there's any reason to do it, even during a hearing, people have the opportunity to request a break. There's no rule against that, although probably not necessarily appropriate.
Okay.
Makes sense?
Makes sense. Makes perfect sense.
Okay. So I think we're good to go, ready for the hearing. Sounds good, Bill?
I agree.
Okay.
Thank you, Anita.
Welcome, everyone.
Hello.
Do we have everyone here? I think we do. Oh, we're missing the
Who are we missing?
other party.
Hi, Presiding
Oh.
Officer Nancy. This is Jennifer. We do have all parties present.
We do?
Right.
Okay. They just aren't on my screen for some reason. Okay, perfect. Okay, so let's get started, ladies and gentlemen. I now call this disciplinary hearing to order. The Professional Standards Committee is charged with holding appropriate hearings for the North San Diego County Realtors in accordance with the procedures set forth in the association's bylaws for matters concerning alleged unethical conduct or other violations of a membership or MLS duty. The hearing panel meeting here today is a panel of Professional Standards Committee members that has been selected to ascertain the truth in this disciplinary hearing and to render a decision on the testimony and evidence presented. It should be reminded that this is a disciplinary hearing, not an arbitration, and this hearing panel cannot award money damages, regardless of the outcome of this hearing. At this time, I would like to introduce the members of this hearing panel. My name is Nancy Lane, and I am the presiding officer. The other members of the hearing panel are Kim Babcock and Mindy Landry. I now ask that each of you introduce yourselves and indicate your role in today's hearing.
I'm Realtor Lucy. I'm the complainant.
Thank you.
I'm Realtor Bill. I'm the respondent.
It's terrific.
And I'm Anita Quillman, and I'm the ethics advocate for Respondent Bill.
Thank you so much. Now that introductions have been made, I want to inform each of you that today's hearing is being recorded. I kindly request that each of you identify yourself prior to speaking so that the recording reflects who is speaking. Also, it is important that only one person speak at a time. Cell phones and other transmitting devices may not be operated during the hearing absent specific advanced authorization from the panel chair. The purpose of recording this hearing is to preserve a record of this hearing in case a party wishes to request a review by the association's board of directors. If, after receiving our decision, a party determines it would like to file a review, the party may purchase a copy of the recording upon written request. Please contact association staff for the form. No other recording or use of the recording is permitted. Parties' access to this recording is not a due process right, and the absence of such a recording shall not invalidate the decision of the arbiters. All persons present are advised that the proceedings, any testimony given, decisions, and recommendations of this hearing panel are considered confidential. All parties in this hearing are advised that failure to keep these proceedings and the resulting decisions confidential is a violation of your agreement to abide by the association's rules and procedures for this hearing. Our decision and recommendations will only be distributed to the parties. The association staff is required to continue processing this matter, and the association's board of directors for final action. This hearing has been convened to consider the complaint of Realtor Lucy against Realtor Bill, which alleges a violation of Article 1 and 3 of Realtor Code of Ethics and the MLS Rules 13.2 and 13.7. Before we proceed further, this proceeding is not a court of law and is not governed by the technical rules of evidence that may apply in court. This hearing panel shall seek to determine all ascertainable and relevant facts pertaining to the matter under consideration to arrive at a peer judgment and decision that is fair to all parties. The hearing panel has discretion to determine its own rules of evidence and its own procedures to be followed to achieve the objectives of equity and due process. The following has been generally accepted and ruled on by this hearing panel as procedures for this hearing. All parties or their representatives to these proceedings will be allowed a full opportunity to be heard on matters relevant to the issues. The hearing panel may rule at any time during this hearing on the relevancy of testimony being given or questions being directed to any party or his or her representative or to witnesses providing testimony. All parties will be asked to swear or to affirm that the testimony given is the truth to the best of their knowledge. A party may be represented by legal counsel. However, no party may refuse to respond directly to requests for information or questions addressed to him or her by the hearing panel members, except on the grounds of self-incrimination or other grounds which the hearing panel deems appropriate. This hearing panel will not tolerate any effort by a party or his or her counsel to harass, intimidate, coerce, or confuse the hearing panel members, witnesses, or any party to the proceedings. The hearing panel may rule at any time on the admissibility of the evidence. As presiding officer, I will keep a record of the evidence introduced at this hearing and mark each with an exhibit identification number and date. All exhibits included in the hearing record may be used in part or full by the hearing panel in their deliberations. The hearing panel members are individually authorized to ask questions as they deem pertinent and significant at any time during this hearing. To preserve order, I will rule on questions or testimony by the parties and their representatives or by witnesses in these proceedings. If deemed necessary, I will order a recess to consult with the hearing panel members or with legal counsel advising the association concerning such rulings. Okay, at this time, I request that all persons present in the room that expect to testify at this hearing be sworn or to make the appropriate affirmation in lieu of being sworn. Raise your right hand and one at a time, state your name. Following the questions I will pose, answer in the affirmative if you do so swear or affirm. Do you swear or affirm that you are who you say you are and that you are the only person or people, as appropriate, present in the room.
Realtor Lucy, I do.
Realtor Bill, I so swear. I agree.
Thank you. Do you swear or affirm that the statements you are about to make at this hearing are the truth, the whole truth, and nothing but the truth, given freely and without reservation?
Realtor Lucy, I do.
Realtor Bill, yes, I do.
Thank you. I am now placing all witnesses in a waiting room, and we'll bring it back to you when it is time to testify, since we don't have any witnesses. All parties should have been mailed or provided a copy of the outline of procedure for this hearing. Do you have any questions regarding the outline of procedure for this hearing?
Realtor Lucy, no.
Realtor Bill, no.
Let the record reflect that neither party or their representatives have questions. Each side should now make, excuse me, a short opening statement and should not immediately jump to presenting all of their evidence. The complainant will now have an opportunity to make an opening statement to state her case.
Realtor Lucy, basically, my complaint is that Realtor Bill let his clients into the property unaccompanied, and it's completely unprofessional.
Okay. And Realtor Bill, you now have the ability to present your opening statement, again, not presenting evidence.
Realtor Bill, this transaction went really well. I don't understand all this trouble, but I get it. Thank you very much for your time to be here. I was in the middle of something else, and I did give them my key, as in let them into the property. But I had a lot of stuff going on, and I just did. So, but we'll present evidence and we'll go through that. Thank you.
Okay. The complainant will now state her case and present any witnesses or evidence she may desire. Cross-examination of the complainant's witnesses by the respondent will be allowed.
Realtor Lucy here. So I was in a transaction with Realtor Bill for my listing at 603 Rose Drive. I was the broker and listing agent. And my client, Bill just completely had unprofessional behavior. He let his client into the property without my clients or my permission. He did this on June 16th, and I believe you have a copy of the lockbox entry log reflecting that, reflecting his access to the property. Upon entering the property at this point, his buyer entered without him, which is unheard of. I can't believe he did that. Not only did the buyer enter the property, but they entered with 4 additional people, completely unaccompanied. My client was so upset. She had no idea what they had done or not done because they weren't accompanied by Bill. She called me completely upset when she got home. She travels outside of the area for work, and she's gone from Thursday of every week till Sunday. And when she got back, her neighbor approached her and told her what had happened. And so she has video cameras, and there was a video of the buyers entering the property with these 4 other people. Again, we don't know who they are. And they entered the property, and there was no sign of Bill anywhere. Because my client's neighbor, Helen, was so concerned about this activity, she took photos, which you also have a copy of that, and you have a copy of the video showing them entering without Bill. We just thought this was completely unprofessional. We didn't give them any permission to do so. And he knows that per the MLS rules and the listing agreement, he's supposed to accompany them. Not only did they enter the property unaccompanied, but they accessed my client's mailbox and put her mail on the kitchen counter. There was no reason for them to go into the mailbox. This is just completely completely unprofessional behavior. And, you know, he can't be trusted. So I respectfully request that you find him guilty in violation of Article 1, Article 3, and MLS Rules 13.2 and 13.7. MLS Rule 13.2 specifically states that a participant or subscriber must be physically present on the property at all times when providing access to a listed property unless the seller has consented otherwise. This clearly did not happen by me or my client, the seller. And also MLS Rule 13.7 says that no MLS participant or subscriber may enter a property or open a lockbox without the listing broker's permission. Again, per the videos, the photos, the lockbox entry, it shows his card was used, and in the videos and photos, he wasn't present. This behavior is completely unprofessional and cannot be tolerated. Thank you.
Do you have any questions that you would like to ask before you go into your presentation of your facts, Realtor Bill?
Yes, I do. Please, Realtor Bill. Lucy, do you have anybody in your office who is named Peggy, Paula, Penny at the office?
We do have somebody in our office named Peggy.
Were they working on that Friday before the Sunday showing?
It's possible that they were. She generally works our up desk, so that's a possibility, but she did not have ability to give you permission to enter.
Well, she said that you were currently out of town because of did you have, excuse me, did you have a personal emergency going on that weekend?
Excuse
I
me,
did.
it doesn't, excuse me, I'm going to interrupt here. The reasons for the lack of response isn't necessary, but let's move forward.
Okay. I, I, did you talk to that Penny or anything like that after Friday, between Friday and Sunday?
To be honest, I don't recall.
Okay. She was the one I talked to. I got permission to go in. I told her that, and she said she would contact you. But that's not a question. I'm sorry.
Okay, so Respondent, Realtor Bill, why don't you state your case and present any evidence and witnesses that you would like to?
Okay. As I don't have any witnesses. As my case is that I called on Friday to I talked to Peggy, I guess, in the office, and she informed me that the owner wasn't even in the property, up until Sunday, and that Lucy was currently out at an emergency. I said, hey, I would call Lucy, but she said that she would inform Lucy of what was going on and let her know that we were going to be there. While I was that morning, Sunday, I was bringing the family because they wanted to do measurements and they wanted to show the rest of the family because they're all excited because they're almost done with escrow, as they were wanting to get measurements and also kind of look at the property and see themselves. So I was going to show the family that particular weekend because the family couldn't be there after the escrow closed because they were leaving town. But unfortunately, while I was driving over there, I had a huge issue blow up on another deal that I had to spend a lot of time just trying to get back to normal. So I was stuck in my car, kind of dealing with my laptop and the phone, I wasn't able to get in there. I did hand the key off to the buyer and allowed them to go in. I don't know about the mail or anything like that about the mail, but I do know that I did hand off the key, and I shouldn't have done that. And I did make a mistake on that the process, but I did. But I will state that the everything went fine. The seller got a great deal, everything went through with escrow. Everything was closed out, and the deal still went through. So I'm not 100% sure what's the problem, but I understand that. I mean, I did make a mistake by giving up the key, and that's thank
Realtor
you.
Lucy, do you have any questions for Realtor Bill?
I just want to reiterate that you so upset my client she was ready to cancel escrow. I just can't believe you would have such unprofessional behavior.
Okay, so does the panel have any questions for either the respondent or the complainant? Would anyone else like to make any other statements?
I have a question.
Okay, Kim?
Realtor Bill, so you didn't enter the property or go on the property at all that day?
I was outside. I was outside in the street with,
In the street.
but I did not enter in. No,
And you said that you did give so you got the key out of the lockbox. Did you get the key out of the lockbox?
yes, I did get the key out of the lockbox as I was about 15 feet away while they went inside.
And then you gave the key to the buyers outside the home to go in.
Yes, I did.
Okay, and so you didn't open the door for them even?
No, I did not open
Okay.
the door for them.
Okay.
In retrospect, it probably wasn't a great idea to do that.
Well, I was gonna ask you, what did you think that was okay? Did you think it was a good idea?
At the time I did because I was in the middle of something else but in retrospect, I don't think it was a good idea.
Okay. No other questions?
I have a question.
Okay, Mindy?
This is Mindy Landry, and I'm one of the panelists. Bill, how long were the buyers in the property?
I don't recall the full amount, but I believe it was about 10 to 15 minutes.
Okay. All right, thank you.
I do want to say that nobody got hurt. I mean, nothing was broken. Nothing, the deal still went through. Nothing was broken nothing damaged I just want to make sure that that's iterated.
Realtor Bill, I have a question. Did you ever at any time before, after, or during that showing go in the property with your buyers?
When I did the original showing, I did walk them through the property, but beyond that, no, not after that.
On this particular showing, did you check the house afterwards?
No, I did not.
Okay, thank you.
Mhm.
Okay.
I do.
Yes,
I do have a question
yes, Anita.
to prompt Bill a little bit. Bill, as we were discussing, I had a question for you, wanted to clarify, to realize that this actually wasn't kind of a last minute showing. He started attempting to make arrangements. Bill, if you clarify that, that was on a Friday.
Correct.
Where you were trying to contact a listing agent to get access because you wanted the appointment on Sunday. So
Correct.
this wasn't some last minute haphazard, leave a message for somebody at a desk, who are they? It was really planning to take care of his clients. And appropriately, if we can't get in touch with the listing agent after a certain period of time, I think it's standard procedure that you call the listing office. We don't have a whole lot of control who's on the other end answering the phone on behalf of that listing office, the broker, or the agent. So, Bill, I'm reconfirming with you our discussion is those are absolutely the steps you took. You chatted with someone, didn't quite have the name right, sounds like, but someone who sounds like they knew what was going on in the property. You called the phone number for the broker. They're the one who answered your questions, gave you additional information, made a note of it, and gave you permission to go to the property, correct?
Correct. I did try to call Lucy. I was unable to call her. Then I called the office at that point on Friday.
Yeah, just wanted that to be clear how that went.
Thank you very much.
Thank you. Would you like to make your closing statement at this time? So we'll start with the complainant, Realtor Lucy.
So Realtor Lucy here. I just feel that Realtor Bill's behavior was completely unprofessional. My client felt violated by not being notified in advance of the showing per the instructions of the listing, and the fact that Bill did not accompany them into the property and make sure the property was secure, and also that they accessed the mailbox. There was no reason for that. I know we closed escrow. but it's still unprofessional behavior and it needs to be addressed.
All right, Realtor Bill?
Um, I'm sorry, I did not, in retrospect, I should have gone in with the property or with the clients and walked the property with them. As to, I tried to get a hold of them. I did what I could to get a hold of the agent, and I was not able to, and I left a message with somebody I thought was capable. After that, as again, I do have to reiterate that everything did go through, and we did close that escrow, and it worked out for both buyer and seller at that point. So thank you.
Ladies and gentlemen, if there's any additional testimony or evidence you would like to present, now is the time to do so. Seeing no further testimony or evidence, I now ask that each party answer affirmatively to the following question. Do you feel the processing of this matter by the association and today's hearing procedures were fair and afforded you every opportunity to present your case? And please answer individually and state your name.
Realtor Lucy, and I do feel it was effective.
Realtor Bill, I do feel it was effective.
Ladies and gentlemen, thank you for your evidence and testimony regarding this matter. We will next go into executive session and deliberate our decision. You will be notified by the association of our decision. This hearing is officially adjourned and you are excused. Okay, now that we have executive session in place, do you have any comments that you guys would like to make over what we've just heard?
I think it's pretty straightforward. I mean, he didn't even really deny anything that she put forth. So rather than that, no, I mean, I think just going over each article, though, I'm not sure I agree on all of them that there was a violation, but I think we can discuss.
Well, let's start with the first one then. On the first one that we have on our list is whether or not he was in violation of Article 3 of the Code of Ethics. And the complainant obviously had that property listed. She was authorized to put a lockbox on the property. She stated in her complaint that her client, Helen Homeowner, routinely went out of town on business every week. And so basically when the property was shown, she was shocked. So when she looked at the tape, she realized that the respondent bill, Realtor Bill, did not accompany them onto the property. I feel like that's a pretty clear, issue with the terms of the Code of Ethics.
Well, I agree with you. Realtors shall not provide access to listed property on terms other than established by the owner and the seller. And it's a realtor's responsibility to never pass that access to anyone who is not authorized to enter the property and without an appointment and an agreement. So I am in complete agreement that he did violate Article 3 and MLS Rule 13.2. That's my opinion.
Kim, did you have an opinion or an idea about that?
Speak.
Yeah, I mean,
Kim.
I agree. I think he's in violation of Article 3 because, even though he was given permission by somebody, that answered the phone at the office, it wasn't authorized by the owner or, the seller of the property. So, technically, he was in violation.
Okay, so the the violation was specific to Article 3. So Article 1 is the one that specifically refers to the showing the property without the without getting permission. So this is for some reason we started with Article 3. So
Yeah.
Article 3 is about the cooperation with other brokers and showing a property on terms other than established by the owner or the seller. So let's go to since we're in agreement on Article 3, let's go to Article 1, which is more specifically regarding that phone call.
Yeah, I mean, Article 1, you know, you have an obligation to your client. You pledge yourself to protect and promote the interests of the client. Obligation to the client's primary, but doesn't relieve their obligation to treat all parties honestly. So was he treating all parties honestly? I think that's the point of 1, right?
Correct.
My
Mindy, did you?
opinion is because he could not reach the Realtor, he did reach out to the office and he did
Right.
get permission to proceed with that showing through the office because he couldn't reach the Realtor. He thought that he had reached the right person at the office that would communicate that conversation to the Realtor, and he relied on that. And so he proceeded with the showing based on the information he was given from the office and the fact that he thought that that information was going to be communicated. So in my opinion, I don't think he was in violation of Article 1.
Kim, do you agree with that?
I concur. Yes, I agree.
Yeah,
Mhm.
I agree. I believe the commentary by his ethics advocate, Mindy, really helped sort of clarify that. I thought that was very helpful. And so we're in agreement that Article 1 is not in violation. Article 3 is in violation. Okay, what's next is the MLS rule 13.2, which was key use and service. The keys may not be used under any circumstances by anyone other than the key holder, including but not limited to lending, borrowing, or sharing keys with others. Access codes may not be provided to third parties without the consent of the seller. The AOR MLS is not obligated to provide service on keys or lockboxes to an individual who is not the registered lessee or owner of the component, and the key will only be used for the purpose of facilitating the sale or lease of a property. So what is our feeling on that one?
Clear cut. He stated so himself. He didn't deny it. He gave the key to an unauthorized user, didn't even go in the property with them, didn't walk the property after. I mean, he gave him the key. So I think that's pretty clear in my mind that he is in violation of that rule.
And I concur.
Okay, so we're in agreement on that one. Okay, so next is 13.7, which is the listing broker's permission. No MLS participant or subscriber may enter a property without the listing broker's permission. And what is our feeling on that one?
I voiced my opinion on that. I thought he got permission.
This is more specific to an MLS, the
Yeah.
MLS version of that same
Yeah.
rule. So we found on the ethics version, this is the MLS version.
Yeah.
Right.
Okay, so I think we're in agreement on that as well.
I do have a question. Do we know if there's any other violations against him for?
Well, we'll determine that once we get to the once we've agreed on the violation or non-violation, and we're going to go into the second half of that, which is when we're talking about what the punishment will be. Or what the fines and et cetera will be. That's where we go to that. So if we are in agreement with the violations or not violations, so what I have currently is Article 1, no violation, Article 3, in violation, MLS Rule 13.2, in violation, and 13.7, no violation. Are we in agreement with those?
Yes, I agree.
Okay.
Agreed.
And now we do have the appropriate question as to whether or not there are any past violations. So staff, if you could answer that question for us.
Hi, yes, this is Jennifer. Yes, last year Respondent Bill was found in violation of Article 3 and he was fined $1,000.
Okay, thank you.
You're very welcome.
Okay, so that will impact our appreciation of the fine schedule. So let's take a look at that. And our recommended disciplinary action do we want to do no discipline, a warning, a reprimand, or a fine?
Based on the fact that he's already had one violation on this very same issue, I recommend a fine.
Okay, so we can go all the way up to 15,000. I think that's a little much. So there are different levels of violation or charges for those violations. What is your feeling on those?
Well, I think it needs to be significant because this is a repeat offender. And he even admits in the hearing that he knows he shouldn't have done it. And he was most
Yeah,
humble
I'm-
about it. And I
I'm
feel
inclined to agree with that. With a second violation, it appears that the lesson wasn't learned the first time, so a little bit more of a hit might be in order.
and I feel bad about it, but yeah.
That's correct. So
Yeah.
what is our feeling? Kim, did you have any input on this?
I just agree with what you guys are saying. I think, he seemed remorseful, but at the same time, if you're gonna pay a steeper fine, you might be so remorseful. You might not do it in the first
Might
place.
stop, right?
Let's not do it and be remorseful. Let's not do
Okay.
it.
Well, I'm going to suggest 5,000 for
Okay.
the code of ethics violation. And then the MLS rule has very specific requirements for their fines, and I believe theirs is 2,000.
And you said the last time he was fined 1,000?
1,000, correct.
Okay. Yeah, I think that's a good escalation.
It is a good escalation. Can we come somewhere in the middle, or do you think we need to be that strict?
Well, it's clear that he didn't learn from his previous and so I think this will certainly create a memorable event.
All right, it's 2 against 1. I'll have to go with it.
I would, I believe, add maybe a class on the
Me too.
code of
I was
ethics.
gonna suggest that.
And they have one that's specific to the code of ethics 1, 2, and 3. And I think that that's appropriate since he was accused of 1, not found guilty, but certainly 1 and 3 are appropriate here. So I believe that would be appropriate for us.
I
do too.
agree. I was gonna suggest some education.
Yeah, I think, given the fact that this is a second offense and for a similar event, I think this will help that. Okay. I have this information. I have what we've discussed. I've been taking notes throughout. If you guys would hand me your notes as well, I'll give them to staff and then we can write up the findings of fact.
Very good.
Sounds good.
I'll
All
give
right.
that-
And I'm going to suggest that we be very clear in that findings of fact about why this is being imposed the way it is, because again, this is something that affects clearly the complainant's client was very upset by this, but this is something that needs to be understood. And so we'll make sure that it's very clear in the findings of fact.
Thank you so much.
Great.
All right, you guys. Good job.
All right.